Big developments in the case of Dwayne "Keefe D. Davis, the man accused of orchestrating the murder of rap icon Tupac Shakur back in the 1990s. All these years later, the former gang leader is behind bars in Las Vegas and is insisting the case be thrown out. And he is implicating another music legend who's making headlines, Sean "Diddy" Combs. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. Dwayne "Keefe D. Davis is said to be behind one of the most infamous killings in history. Tupac Shakur, the 90s rap superstar, was gunned down while riding in a car with Suge Knight after the Mike Tyson fight at the MGM Grand. And over the years, there have been multiple investigations into Tupac Shakur's murder, but there has been one man who has seemed to implicate himself in the assassination again and again and again. Dwayne Davis, also known as Keefe D. By the way, spelled sometimes with two F's, sometimes with two E's, even sometimes with a Y. Gets a little bit confusing, but Keefe D. Now, Davis was reportedly the leader of a sect of the Crips street gang in Compton, California that dealt in drug sales and trafficking. Davis eventually did time in prison on drug charges in the late 90s, but since getting out, he has been more open about his apparent involvement in Shakur's death. Davis released his own tell-all book. It's called Compton Street Legend, Notorious Keefe D's street-level accounts of Tupac and Biggie murders, death row origins, Suge Knight, Puffy Combs, and crooked cops. And he started granting interviews with YouTubers who wanted the inside scoop on what happened on that night back in 1996 out in Las Vegas. So Davis and several members of his entourage apparently attended the Mike Tyson boxing fight. But afterward, in the casino, Shakur had attacked Davis's nephew, Orlando Anderson. The fight had apparently been sparked by a previous beef over an alleged stolen neck chain. So the men eventually separated, the two groups went on their way, but Anderson, Davis, and others that were with them were reportedly still pretty heated over what had just happened. And later that night, allegedly, their plan was to target Shakur and Knight. And Knight, of course, is the head of, or was the head of, Death Row Records, as they were all stopped at a traffic light. This is what happened. Now, in an interview with the Art of Dialogue channel, Davis said he was in the front passenger seat that night with DeAndre Big Dre Smith and Anderson in the back seat of the rented Cadillac. And what happens next? Who fired the shots? Take a listen.
Dre, he was the one that was supposed to shoot, Tupac and Suge, but he got scared, right?
No, he didn't really get scared. He wasn't ready for that. They was youngsters, man. Kids.
But once again, y'all Crips, right? So he should be used to that, right, Dre? So why was
he wasn't ready for that. Everybody got a role, man. Everybody ain't killers. Everybody, you know what I'm saying? Everybody ain't gonna kill.
So
everybody
Dre,
ain't
he
with
wasn't
that.
a shooter?
No.
Okay, so but he was the one that was supposed to shoot up Tupac and Suge, but for some reason he wasn't ready for it, so he gave the gun to Orlando, right?
Something like that, yeah.
And Orlando is the shooter. He's the known shooter. Everybody know Orlando Anderson was a shooter. So Dre got cold feet. He didn't want to do it. He gave the gun to Orlando, and Orlando shot Tupac and Suge.
Yeah, he did his thing, yeah.
Now, let's be clear about something. Anderson has always denied that he was the killer. In fact, he died just a few years after Shakur in another shooting. The other men in the Cadillac, DeAndre Smith and the driver, Terry Brown, they are also both dead. But Davis told a lot of this information to Los Angeles and Las Vegas investigators as well. And this is after he apparently became a confidential informant for a task force that was looking into the murder of Christopher Wallace, also known as Biggie Smalls and the notorious B.I.G. By the way, we're about to talk about Diddy. We did a whole separate Sidebar episode on how Sean Combs' former bodyguard came out recently, spoke on a documentary, and saying that Sean Combs could have been involved in the murder of Christopher Wallace. I encourage everybody to check it out if you're interested. But then going back to Tupac, we go to September of 2023. So this is 27 years after Shakur's death. And Davis was arrested near his home outside of Las Vegas and taken into custody. And since then, after he's been charged with the murder of Tupac Shakur, he and his legal team have been working to get him out of jail and to get his case thrown out. Now, we can say definitively he has lost both of those battles. He has pleaded not guilty to first-degree murder. He's supposed to go to trial in March, but I want to explain a little bit more about this. So earlier this month, Davis's defense team filed a motion to dismiss the case. And as part of his argument, he is pointing the finger, seemingly, at Sean Diddy Combs as the one who really is responsible for Shakur's death. Yeah, this is one of those stories that we've been constantly trying to keep an eye out for, bring you updates as they develop. And for that, I gotta call out our amazing sponsor, Morgan & Morgan, because their support helps us to keep on doing this. But here's the deal. If you're injured, Morgan & Morgan, the exclusive personal injury law firm of law and crime, America's largest injury law firm, that may be who you want in your corner. You know why they have over 1,000 attorneys? Because they win a lot. In the past few months, Morgan & Morgan secured a $29 million verdict for a bicyclist in Philadelphia, a $2.7 million verdict for a car accident victim in Florida, and not to mention $5.6 million for a car crash victim in Georgia after insurance offered that client $0. And even if you think your case isn't worth millions of dollars, why not start a claim and fight for what you deserve? Morgan & Morgan, they make it so simple because you can start a claim from your phone in just 8 clicks. So if you're injured, you can easily start a claim at forthepeople.com/LC sidebar. Now, at the time of Shakur's death, Combs was beginning his meteoric rise to the top of the rap world. He had started Bad Boy Records, now called Bad Boy Entertainment. And of course, there was this ongoing feud, West Coast versus East Coast, with this feud that he had with Tupac Shakur and Suge Knight, again, the leader of Death Row. So I want to take a look at the legal arguments that Davis's team had in their filing. And it reads, Defendant Dwayne Keith Davis hereby files this motion to dismiss on the basis that the state of Nevada has failed to timely pursue these charges against Mr. Davis, failed to provide corroborating evidence to support Mr. Davis's coerced confession, and failed to honor the federal proffer agreement between Mr. Davis and the United States government, thus substantially impairing Mr. Davis's constitutional rights. So 2 big arguments here. One is that the government waited too long to file the murder case, 27 years. They claim that this was done maliciously. By the way, though, typically speaking, there are no statute of limitations for murder. But even if they had filed the charges sooner, this is Davis's other argument, Davis says he's immune from prosecution thanks to an agreement he had with investigators when he was hauled in to talk about Tupac Shakur's shooting. And listen, remember, Bill Cosby, we all remember what happened to him. His conviction for drugging and raping a woman was vacated because his due process rights were violated, since a former DA had in fact made an oral promise to Cosby that he wouldn't be prosecuted. And remember, Cosby relied on that promise to admit some incriminating things about that encounter. So a high court actually determined his conviction should be thrown out. But going back to this, the first big interview that was referenced in the filing is from a couple years after Tupac Shakur died. On July 16, 1998, Mr. Davis was interviewed by Assistant United States Attorney Michael Terrell. Mr. Davis's attorney, Mr. Eddie Fayol, was present. The interview was considered a proffer agreement between the United States government and Mr. Davis, under which any information provided by Mr. Davis would not be prosecuted related to that information. Mr. Davis was repeatedly questioned about the alleged murder of Tupac Shakur. Mr. Davis denied knowing who shot Mr. Shakur. Mr. Davis was asked to speculate as to who shot Mr. Shakur. Mr. Davis stated it was the Compton Police Department under the direction of Suge Knight, owner of Death Row Records. Mr. Davis was asked what would be Mr. Knight's motive, and Mr. Davis responded Mr. Shakur was getting ready to leave working with Death Row Records. At no time during the interview, less than 2 years after Mr. Shakur's shooting, did Mr. Davis state that he or members of Southside Crips were involved in any manner with the shooting of Mr. Shakur. Okay, goes to an issue of credibility. Well, Davis says he was interviewed again in 1999, and during that meeting, he denied that his nephew Anderson was the shooter. Mr. Davis stated that Mr. Anderson was not involved in the shooting of Mr. Shakur. Mr. Davis did discuss that Mr. Anderson was attacked by Mr. Shakur in Las Vegas the night of Mr. Shakur's shooting. Nevertheless, the decision was made to retaliate in Compton since there were so many police around in Las Vegas during the Mike Tyson fight. And during that interview, Davis blamed Compton police for spreading the rumor that Anderson had shot Shakur, although later we know that Davis himself would say that in public statements. But the motion to dismiss also says that Davis was offered immunity during the Biggie Smalls investigation in the early 2000s. The filing reads, the 3 LAPD and FBI agents were part of a task force to solve the shooting of rapper Notorious B.I.G., also known as Biggie Smalls, legal name Christopher Wallace. The task force, through a sophisticated criminal investigation, obtained sufficient evidence that would prove Mr. Davis was the leader of the Southside Crips and his gang was responsible for over 360 kilos of cocaine and PCP. Mr. Davis provided 3 interviews to obtain immunity from prosecution. The final interview were solely questions regarding the Tupac Shakur shooting, which Mr. Davis was also provided immunity from prosecution. So during a December 2008 interview with investigators, that is when Davis allegedly started to spill the beans about his one-time friend, Sean Combs, who he refers to as Puffy. He claims Sean Puffy Combs solicited Mr. Davis to kill Suge Knight and Tupac Shakur for $1 million. Eric Zip Martin, an associate of Puffy Combs, provided Mr. Davis with a gun to exact revenge on Tupac Shakur for the beating Mr. Anderson received. Now, Davis reportedly told the investigators that even though the job had been partially completed and Shakur was killed, neither he nor Anderson ever got paid. He later revealed that he believes Combs had paid the go-between, Zip Martin, who he claims kept the money for himself. And he said much of the same thing in a 2009 interview a year later, because according to the motion to dismiss, the Las Vegas Metropolitan Police Department, as far back as 2009, was in possession of the same set of facts that the Clark County District Attorney is now alleging makes Mr. Davis responsible for the murder of Tupac Shakur. The Clark County District Attorney's Office has offered no reason as to why it waited another 14 years to prosecute a case against Mr. Davis. Mr. Davis has been irreversibly prejudiced by this unnecessary delay in prosecution of this case, and Mr. Davis's constitutional rights have been violated in an extraordinary manner never before witnessed in the annals of the American criminal justice system. Now, of course, there was a response because the prosecutors from Las Vegas called out Davis for being quite dramatic and said he has been telling on himself for decades. So their motion in opposition to the motion to dismiss states, in the years following Shakur's murder, defendant Dwayne Keefe D. Davis confessed to being involved in Shakur's murder in nearly every form imaginable. Defendant confessed to some of his role in Shakur's murder during an interview with LVMPD Homicide in 2009. Defendant admitted to seeking a deadly confrontation with Knight and Shakur in interviews with the producers of the Death Row Chronicles in 2017. Defendant recounted his involvement in Shakur's murder in his book published in 2019. And defendant has gleefully claimed responsibility for the murder of Shakur in numerous YouTube interviews from 2019 up until his arrest. And the prosecution then addressed the issue of immunity from prosecution, right? Well, maybe he's admitting everything because, he thinks he's immune. They have a response to that. Quote, defendant asserts that he has received immunity from prosecution in this case. Defendant has provided absolutely no proof that transactional immunity was ever conveyed by any prosecuting authority. Defendant has provided no federal court order conveying immunity. Defendant has provided no California court order conveying immunity. However, even if he had such a grant, they couldn't possibly cover his criminal liability in Nevada. Defendant also claims that his proffer in 1998 and his statement to Detective Long somehow created immunity for the crime. As the court is aware, the legal community utilizes proffer to describe a contractual relationship between an interviewee and a prosecuting authority. In essence, a proffer agreement allows for statements made pursuant to the terms by the interviewee to not be used against that person. The state does not seek to utilize the 1998 proffer session against defendant and has no idea what the terms of such an agreement were between him and the federal government before he entered his plea. The report seems to reflect that this was a standard proffer where a criminal defendant is interviewed about his knowledge on all possible criminal subjects he may have information about before he's allowed to enter his plea. While he doesn't refer to the proffer agreement with the AUSA Searwright, the terms of that agreement are known. Defendant was specifically informed that this agreement was between him and the federal government. Moreover, the agreement is limited to a single date and time. It allows for the statements to be utilized on cross-examination of defendant if he ever testifies differently. Finally, the agreement is limited by its express terms. Nothing in that agreement suggests the defendant has immunity from any criminal charges. Notwithstanding, it appears to only apply by its express terms to an interview on December 1st, 2008. Certainly, defendant is free to litigate the admissibility of the December 18, 2008 statement. However, case law establishes that defendant's mistake of fact about its admissibility, particularly where he had a lawyer present who knows the specific terms of the agreement, would not lead to suppression of the statement, meaning it can't come into evidence. And on Tuesday, Clark County District Court Judge Carly Kearney agreed with the prosecution, saying Davis has provided no proof that he had any immunity deals, and we're going to expect to hear in the next few days if Davis's legal team plans to appeal that decision to the state Supreme Court. Remember, going back to Cosby, it was the Pennsylvania Supreme Court who ultimately determined that his conviction should be vacated because he had entered into an immunity agreement. So we shall see what happens. Davis says he eventually became a confidential informant to a task force that was investigating the murder of Biggie Smalls. So this is Shakur's main rival at Bad Boy Records out in New York. And we know that Biggie Smalls was actually gunned down in Los Angeles. But prosecutors countered Davis's claims by saying there's no proof of any sort of immunity offer here, and that even if Davis had been offered some kind of protection from prosecution in California or the federal court system, that wouldn't apply to his case in Nevada. And the judge agreed, opting not to throw out the case, denying the defense's motion. One of the most interesting things to come out of that motion to dismiss, though, is just how many times Davis talked about Sean Diddy Combs over the years, the disgraced rapper and music mogul that we have been focusing upon a lot here on Sidebar, currently in a detention center on federal charges of sex trafficking and racketeering and prostitution, headed to trial out in May. But I want to talk about what Davis has to say about him. What he has to say about, I should say, Puffy. That's one of the many monikers that Combs has adopted over the years, and that's how he refers to him in this filing. So Combs started his meteoric rise to stardom in the early 90s as well. Started Bad Boy Records, now Bad Boy Entertainment out in New York. There was the big East Coast, West Coast beef, Death Row versus Bad Boy. And Davis says that Combs used that as an excuse to put out a hit, an assassination order on Tupac Shakur and Suge Knight. So let's take a look at what Davis had to say about Combs, and a little bit of note about this. So Davis has told many versions of his story to police over the years, changing some details, leaving other details out. Got to take that with a grain of salt about his credibility. Sometimes he would admit the things, sometimes denying them. Again, just take that for what it is. In fact, I will also tell you, the state talks about that in their opposition to the motion to dismiss, which says on December 18, 2008, defendant was interviewed by task force officers at his lawyer's office. This interview was surreptitiously recorded by LAPD Detective William Holcomb. During this interview, defendant confessed in detail about his involvement in the murder of Tupac Shakur, consistent with his book and subsequent YouTube.com statements. And what Davis revealed in an interview with the Art of Dialogue YouTube channel in 2021 is that his nephew, Orlando Anderson, shot Shakur from the backseat of the rented Cadillac. But during an interview with the FBI in 1999, Davis apparently said something completely different. According to the FBI report, which was included in the motion to dismiss, Anderson was not involved in the shooting death of Tupac Shakur, and neither Davis nor his group killed Shakur or Christopher Wallace, aka Notorious B.I.G. Davis does not know who killed the two rap stars. He believes that either individuals from New York associated with Puffy Combs or individuals associated with Death Row Records could have killed Shakur, and that individuals associated with Death Row Records killed Wallace. Okay. So, again, changing stories. And by the way, Davis goes on to say that he was introduced to Combs in the early 90s by a man named Eric Zip Martin. This is another alleged drug dealer. And this is where we get into it. So the report reads, in or around 1992, Martin introduced Davis to Sean Puffy Combs. Davis recalls the introduction occurring at the Paradise nightclub on Santa Monica Boulevard. After speaking with Combs, Davis agreed to allow Combs to use his 1964 Chevy in a music video. The video featured the artist Usher. After the vehicle was damaged in the production of the video, Combs paid $2,500 to have it repaired. And by the way, according to Davis, Combs was scared of Suge Knight. And this was a man who had a reputation for being, sometimes violent and extreme. And that moves us now to this DEA report. So there was a DEA report from a 2008 task force meeting with Davis that was also included as an exhibit in the motion. And in it, Davis talks about the murder of a man named Jai Robles. This is Knight's bodyguard. He was killed in Atlanta in 1995. And according to Davis, he'd heard a rumor that an associate of Combs had killed Robles. The report says Combs requested to speak to Davis and asked Davis if he thought it was safe for Combs to come to Los Angeles for a concert. Combs expressed his concerns about Knight and possible retaliation related to the Robles murder. Davis advised Combs that he would provide 40 or 50 tickets to the concert. Davis could provide an entourage. Combs agreed, and Davis and his crew in fact attended the concert in support of Combs. Davis recalls the concert taking place in Anaheim, California. It was at this event that Combs began to solicit Davis to kill Knight and Shakur. Combs asserted something to the effect of, "I'll give anything for those dudes' heads." Quote, at a later date, Dwayne Davis, Eric Martin, Corey Edwards, Sean Combs, and others met at Greenblatt's restaurant in Hollywood. Well, at the restaurant, Combs summoned Davis into the downstairs area. Combs again told Davis that he needed to get rid of Knight and Shakur. Combs offered Davis $1 million to handle the problem. Davis remembers Combs being very afraid of Knight. So after the car that Knight and Shakur were in was hit by a hail of bullets back in 1996, Davis says that Combs wanted to know if that was the result of him allegedly putting out a hit on Shakur. The task force report states, well, at the restaurant, Martin told Davis that Combs had called Martin and asked, "Was that us?" Davis asked Martin when he would receive compensation for the shooting. Martin told Davis he would get the money when he returns to New York. Additionally, while at the restaurant, Combs called Martin again. Martin then handed the phone to Davis. Combs again inquired, "Was that us?" Davis recalled Combs sounding elated at the situation. Again, this is all allegations, but quite an allegation nonetheless. Now, Davis reportedly told the investigators that even though the job had been partially completed and Shakur was killed, he nor Anderson ever got paid. He later revealed that he believes Combs paid the go-between, again, Zimp Martin, who allegedly kept it for himself. So we mentioned a moment ago that an LAPD officer had recorded statements that Davis made in 2008. The state included a transcript of that interview in its filing, and in the transcript, WH refers to Wayne Higgins. This is Davis's lawyer during the interview. Q refers to the questions, and the A's are Davis's answers. Okay, so it says, WH, okay, now go on and ask whatever you want. Q, Puffy Combs. A, yeah. Q, does he play a role in this thing? WH, answer the question directly. Tell him what you think. A, did he play a role in this? WH, don't hesitate, just tell him. Question, yes. Answer, yeah, I think he did. And later in the interview, Davis said, yeah, I feel, I wish it would never ever, I wish I never met Puff Daddy, period, I swear to God. Question, yeah? Answer, he messed up my life, man. I was rich up and under the radar, all that, man. Question, that's all gone? Answer, it's all gone. Now, what about Combs' alleged involvement in the death of Biggie Smalls, legal name Christopher Wallace? Okay? This was a big one. Smalls was gunned down in a drive-by shooting out in Los Angeles in March of 1997. You might be saying, I thought they were friends, right? Anybody who followed this. We did a whole sidebar on this, but Gene Deal, a former bodyguard for Combs who has recently started doing interviews and offering theories on Combs' alleged bad behavior, now says the rapper could have been involved in killing Biggie. So Deal, who was reportedly Combs' bodyguard from 1991 to 2005, sat down for the documentary Diddy, The Making of a Bad Boy, that aired on Peacock. And according to him, Combs was acting weird in the lead up to Biggie's murder. He says in the documentary, the week in which Biggie was murdered, he was just acting real anxious and trying to get big at this party. And what was crazy was Big was telling people he had to be in London, but Puff was telling people he ain't going to London that whole week. You fast forward to the day of the party and Deal says, I'm sitting up in the Beverly Hills Hotel and I get a phone call. It's about 9 o'clock and they say, Gene, get ready, we going to the Vibe party. I was like, we going to the party? We don't have no security. But according to Deal, tried to warn Combs this probably wasn't a good idea. I say, yo, Puff, I got some intel, bruh. He said, what? I said, yo, man, if we go to this party tonight, one of us is going to get killed. Somebody going to die because now we got East Coast, West Coast beef. He said, yo, Gene, I don't want to hear that S, so we all jump in the car. I was in a car with Puff. Big was in his own car. And the next thing you know, you hear pow, 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 pow. Biggie was shot 4 times, died right after arriving at the hospital. And according to Deal, Combs showed up at the hospital, seemed shocked that Biggie was dead. And we asked celebrity criminal defense attorney Brian McMonigal about this latest accusation against Combs, who's already facing these 3 federal charges related to the so-called freak-off activity. And again, he's facing dozens of civil lawsuits. But here's what Brian had to say.
I don't see this. This is a 30-year-old accusation. And it seems to me that it's getting to a point where Diddy's concerned, where it's dangerously getting to piling on in a way that I think might just help him. As I thought about this last night, once I saw the article in the Post and was referenced on the documentary, it seems to me that there are a lot of people now that are jumping on this bandwagon of making what I would say are baseless allegations against this guy. This one in particular just smells to me. Did this guy say any of this stuff over the past 30 years to anybody in law enforcement? Has there ever been any kind of a suggestion that he was involved by law enforcement? It seemed to me that he was in a close relationship with Biggie, and that if anything, he was on the other side of this East Coast, West Coast fight. So the one thing that I would say about it is just bringing this kind of full circle to this upcoming trial. They're going to be looking for things like this, the defense in this trial. They're going to be looking for accusations that are stretched. They're going to looking for moments that they can disprove things. And make no mistake about it, there'll be a few things like that. And hope that that'll give them the kind of strength and ability to diffuse perhaps as many of these allegations as they can where this indictment's concerned.
Now, to be clear about something, Combs has always denied any involvement in the deaths of Tupac and Biggie, and he certainly has not been arrested or charged in connection with their deaths in any way. As for Davis, we go back to him. It's going to be up to his attorneys to decide if they will appeal the judge's denial of their motion to the state Supreme Court. In the meantime, Davis has been denied bail, so he's going to be sitting in a Las Vegas jail until his trial, which is scheduled to begin in March. We'll keep our eye on it. Sean Combs' federal criminal case out of the Southern District of New York, where he faces charges of racketeering conspiracy, sex trafficking through force, fraud, or coercion of victim one, and transportation to engage in prostitution. Trial currently scheduled for May 5th, 2025. I want to go back to the indictment because this is really where it centers upon it. So it alleges that Sean Combs and other members and associates of the Combs enterprise wielded the power and prestige of Combs' role at the Combs business to intimidate, threaten, and lure female victims into Combs' orbit, often under the pretense of a romantic relationship. Combs then used force, threats of force, and coercion to cause victims to engage in extended sex acts with male commercial sex workers that Combs referred to as, among other things, freak-offs. Freak-offs were elaborate and produced sex performances that Combs arranged, directed, pleasured himself during, and often electronically recorded. In arranging these freak-offs, Combs, with the assistance of members and associates of the Combs enterprise, transported and caused to be transported commercial sex workers across state lines and internationally. Freak-offs occurred regularly, sometimes lasted multiple days, and often involved multiple commercial sex workers. During freak-offs, Combs distributed a variety of controlled substances to victims, in part to keep the victims obedient and compliant. Sometimes, unbeknownst to the victims, Combs kept videos he filmed of victims engaging in sex acts with commercial sex workers. After freak-offs, Combs and the victims typically received IV fluids to recover from the physical exertion and drug use. And let's not forget that prosecutors allege that these freak-offs weren't just happening years and years ago. In one of their letters to the court, they wrote, indeed, since at least in or about January 2024, when the defendant was unquestionably aware of the criminal investigation, the evidence shows that he is engaged in multiple freak-offs, some involving the interstate transportation of individuals to participate, has continued to use narcotics, and has contacted multiple witnesses. Now, I think there's a fair argument to say that Sean Combs' defense counsel isn't going to shy away from the term freak-off. They might accept, yeah, Sean Combs called these sexual encounters freak-offs. Yeah, they weren't with commercial sex workers, but maybe it was group sex, or maybe it was things that were filmed with him and a partner of his, but doesn't make it illegal. The way it becomes illegal is if you do bring in these sex workers, if there is some sort of force or fraud or coercion that is used, or there are narcotics that are used, and this idea that it wasn't on the up and up. But I think they're going to say it might be different from what you and I do, but it's not necessarily illegal. I want you to keep that in mind. And obviously, as you heard there are elements to the racketeering charge, this kind of idea that there was a criminal enterprise that engaged in all sorts of illegal activity. Sean Combs was leading it. The sex trafficking, again, you particularly moving people across state lines for commercial sex acts. There has to be an element of fraud or force or coercion. Combs' attorneys filed a letter asking Judge Arun Subramanian, this is the judge in the Southern District of New York who is overseeing this case, they are asking him to order the prosecution to electronically produce videos of the freak-offs to the defense. And the reason they want these electronically produced. The reason they want copies of these in their possession to review and analyze, and why they need the court to step in, is because they say that under the current protective order in this case regarding how evidence will be viewed and disseminated, the video evidence is available for inspection only, right? They have to go to a certain place provided by the prosecution in order to view these videos. They say that's not fair. And according to the defense, the federal prosecutors refuse to produce over these videos to them. But more importantly, and this is the key, Combs' lawyers write, we need these videos because they prove our client is innocent. Quote, having reviewed these videos, it is now abundantly clear that they confirm Mr. Combs' innocence and that their full exculpatory value cannot be investigated and used unless they are electronically produced. The 9 videos at issue are the so-called freak-off tapes with victim 1 that the government has repeatedly referenced, causing wild speculation in the media. Contrary to what the government has led this court and the public to believe, the so-called freak-offs were private sexual activity between fully consenting adults in a long-term relationship. Like many Americans in the privacy of their own bedrooms, they sometimes filmed their sexual activity. These videos unambiguously show that the person alleged in the indictment to be victim 1 not only consented but thoroughly enjoyed herself. And we believe victim 1 to be Cassandra Ventura. This is Diddy's ex, who first filed that initial sexual assault lawsuit against Combs back in 2023. She was also in that infamous surveillance footage that was published by CNN months ago, where you see Sean Combs in a towel beating Cassandra Ventura, dragging her, kicking her. The filing goes on to say, quote, moreover, contrary to innumerable sensationalistic media reports, the videos do not depict sex parties. There are no secret cameras, no orgies, no other celebrities involved, no underground tunnels, no minors, and not so much of a hint of coercion or violence. So not only talking about the allegations in the indictment, but also all of the claims that have been made in the media as well. Now, far from the government's lurid descriptions, the videos show adults having consensual sex, plain and simple. At bottom, this case is about whether victim 1 was or was not a willing participant in her private sex life with Mr. Combs. The videos confirm that she plainly was. And the defense in this letter describes victim 1 in these videos as, quote, happy, dominant, and completely in control. They write, there is no evidence of any violence, coercion, threats, or manipulation whatsoever. There's no evidence that anyone is incapacitated or under the influence of drugs or excessive alcohol consumption. There is certainly no evidence of sex trafficking. That's what they say. They go on to write, the premise that freak-offs are inherently dangerous shows that the government seeks to police non-conforming sexual activity and that it assumes, despite all evidence to the contrary, that a woman's willing participation must have been coerced. So again, that idea of doesn't seem like they're shying away from these freak-offs, but saying, while the freak-offs might be unusual, they're not illegal. Now, the defense also says that they reviewed photographs that they say victim 1 allegedly sent to Sean Combs, and they too appear in their characterization, quote, to reflect entirely consensual sexual activity. And the defense also claims in this letter that these recordings corroborate what witnesses have told the government. And they don't really explain more about that, but that seems to suggest that these witnesses are going to be helpful to Sean Combs' defense. Maybe these are sex workers who were there and say, look, our opinion, Cassie consented to everything that was going on, or victim 1 consented to everything that was going on. Now, we actually spoke with criminal defense attorney Bradford Cohen about this, and he's represented celebrities like Drake, Lil Wayne, Kodak Black. And the question is, based on the defense's characterization, is this the end of the prosecution's case, right? Do these videos prove that Sean Combs is innocent? Is there anything more? Take a look.
I think it's interesting because, from the very beginning of this case, I was saying, I think that the original tape showing the violence against Cassie, I think the original tape was leaked by her team to show that she is a victim and not a willing participant or a co-defendant. So I've been saying that for a long time. So to hear this, that, okay, we've seen these 9 videotapes, and these 9 videotapes kind of back up what we've been saying the whole time, that it's consensual sex between adults. It's an interesting thing to say, because I think that the videotapes are going to show that Cassie probably was engaging with another individual. The videotapes are probably going to show that it wasn't a hidden camera, maybe that she was making faces or saying something to the camera that confirms that it wasn't a hidden camera or someone's talking on camera. All those different things definitely help his case. Is it a smoking gun, as we say? No, probably not a smoking gun, because she's going to still say, listen, I was still under the control of Sean Combs. He was physically controlling me. He was mentally controlling me. That's going to be where she goes with this whole thing. And that's where that tape of violence comes in to show that, yeah, it might have looked like I was doing these things on video, that I was a willing participant. But in reality, I knew if I was not a willing participant, then something else would have happened to me physically or mentally.
Now, you might be saying, well, look, the fact that the tapes exist, Jesse, that shows that Sean Combs is guilty, because the government alleges he secretly filmed these encounters and used it to blackmail victim one to stay silent, to do what he wanted. The defense, to do what he wanted. Well, the defense has an answer to that in their letter. They write, these recordings were not on Mr. Combs' devices and were not seized from his homes. Rather, victim one kept these videos on her own device for years and produced them to the government herself. Now, Bradford also had an interesting take on that as well.
If the defense had these tapes, or Sean Combs had these tapes, when the tape came out or when the accusations came out that she was not a willing participant in this sex, you don't think those tapes would have been leaked? Like,
well, he would have gotten in a lot of trouble if he did that, right?
Well, before the charges were even filed, when she said, when she first hit him with the civil complaint, and in that civil complaint says she was not a willing participant, she was not involved in these things, all these different kind of accusations in that civil complaint, you would at that point say, what are you talking about?
He settled with her the next day. And if you're him, I don't want to release these videos of me, my private sex life. He probably didn't want to.
No, but you could, there's a way you could leak it to make sure her version of events was questioned.
Now, in terms of the defense's argument for why they are entitled to electronic production copies of these videos, they argue that this is a form of exculpatory evidence covered under what we call in the law Brady, that the government has to turn over, that Combs has a constitutional right to properly prepare for his defense. He has a due process right. That's why he should have it. And they also cite the federal rules of criminal procedure, specifically Rule 16, which states in part, upon a defendant's request, the government must permit the defendant to inspect and to copy data that is within the government's possession, custody, or control, and that is material to preparing the defense. And here they argue that videos of the freak-offs, they are material because that's essentially the prosecution's central point in this case, the freak-offs. And they argue the government has not presented enough evidence to withhold the videos because this is not child pornography. This is not classified information. Now, the prosecution responded in a letter of their own to the court, and they didn't directly respond to the Rule 16 argument or what the tapes show, but they argued that the defense's letter violated the protective order that has been put in place by the court. That under the protective order, that no portion of the videos should have been filed on the public docket without being filed under seal or without the defense first conferring with the government as to the designation. And they said neither occurred. Quote, instead of conferring in advance or redacting all content related to the videos, the motion blatantly violated the protective order when it left unredacted descriptions and characterizations of material designated AEO, attorney's eyes only. And they argue this threatens the privacy of victims, and they are asking the court to remove it from the public filing and have it be refiled with redactions. Well, the defense responded to that in a follow-up letter, and they said, look, we will make the requested redactions, but they want the court to step in. And they want to be able to refile this with narrower redactions. Why? Because they argue that the government's request was way too overbroad, that the government, they already told everybody what all of this is about, that they have been quite explicit and specific about freak-offs. And they also argue that there is a presumption of public access here. This is about the government's key piece of evidence in this case, the freak-offs, and that Mr. Combs' trial rights are being compromised by not having proper access to this material. They write, indeed, the public can only have confidence in the conscientiousness, reasonableness, or honesty of judicial proceedings if the documents on which judges rely are publicly available. And they say the government provides no satisfactory or adequate reason for why this information needs to be sealed. And I want to read you this part in its entirety because I think this is really key to the defense's argument. So in their letter, they write, quote, "While victim one may have privacy interests that justify keeping the videos themselves under seal at this stage, including details of the content of the videos, the fact that victim one was filmed while participating in the so-called freak-offs is public information. Indeed, the government has publicized that these were extended sex acts with male commercial sex workers and elaborate and produced sex performances that were electronically recorded. The government has publicized gratuitous details, including the use of baby oil, lubricant, extra linens and lighting, room damage, and delivery of IV fluids. The government even held a press conference publicizing the seizure of more than 1,000 bottles of personal lubricant and baby oil. And the government has publicly asserted that during the freak-offs, alleged victims were subjected to physical, emotional, and verbal abuse, including being hit, kicked, and dragged, and that alleged victim claims are corroborated by videos of the freak-offs. Faulting the defense for characterizing that same evidence as exculpatory and consensual is an unfair double standard and demonstrates the government's intent to mislead the public and the court. To accept the government's broad reading of the protective order would turn it into a tool to shield the public from any interpretation of the evidence that could be favorable to Mr. Combs, after the government has been able to tout its own inculpatory interpretation. The result will be an unfairly polluted jury pool, manufactured by the government's misleading narrative and widely disseminated by the press. So the question becomes, how much will be revealed about these tapes either before trial or even during trial? And you wonder how much a jury will be sitting there being shown these tapes, looking to see if there's illegal or consensual activity going on. And also, by the way, what's the reporting going to look like from inside that courtroom, right? No cameras are going to be allowed, but the reporters will presumably be front and center watching these videos because there'll be exhibits during this trial, videos of the alleged freak-offs. But I think it is fair to say that the government is not and cannot, in order to prove their case, rely solely on the tapes of the freak-offs, right? They have to have more corroborating information, whether it's witness testimony, whether it's the victim's testimony. There needs to be more to show that this isn't just group sex, but that it was forced, that it was coerced, that there was an element of violence or fear, that these sex acts were done through illegal means for Sean Combs' pleasure. We'll see what happens. That's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. Speak to you next time.